Zaire Webb accepted a 4-year athletic scholarship from Washington State University. The university canceled his scholarship and dismissed him from the team after he and a teammate were arrested at Wal-Mart for stealing multiple items, including home drug kits. Webb appealed to the university's Athletic Award Appeal Committee, who upheld Coach Leach's decision. Webb then took this issue to court, arguing his right to due process was violated when he was prevented from being present for the duration, he was prevented from questioning witnesses, and from presenting his own witnesses. The court dismissed Webb's claims, and now it is being argued at the Division III Court of Appeals.
Good morning. Tyler Wade on behalf of appellant and cross-respondent Zaire Webb. May it please the court. The case today revolves around 3 primary issues. First, whether WSU provided adequate due process in the athletic aid appeal hearing. Second, whether WSU employees are immune through either quasi-judicial immunity or qualified immunity in light of the precedent that we have and the lack of safeguards that were present in the case. And then third, the issue I'd like to discuss is whether or not WSU is obligated to follow the handbook and whether the handbook created enforceable contract and obligations that they were bound by. And I would point out that those issues are going to primarily be factual questions that should be decided by the trial court on remand. But if the court's okay, I can take them in that order, but I'm happy to go at it about it at a different way if you prefer.
Mr. Wade, I'd like you to start with the second issue, it's specifically dealing with quasi-judicial immunity. I know you discussed the Taggart case, and I think that there's a subsequent case decided by the same group of justices about a year later. Can you discuss quasi-judicial immunity, please?
Yes, Your Honor. I think the second case you're referring to is the Lutheran daycare case. And the thrust of those arguments in those cases revolve largely around the amount of procedural safeguards that are present and whether or not certain functions are judicially comparable to functions that the judiciary typically carries out. So we're looking at things like, is the process adversarial? Are these folks insulated from political influence? And most importantly, is there the ability to correct errors on appeal? So in this case, the lack of safeguards is the biggest issue because, as is pointed out in our materials, Mr. Webb, he didn't have a record that was created. He was unable to hear the evidence against him, and there's nothing for a superior court to really look at on appeal. Typically,
what does Taggart say about procedure as far as I think in that case there was a lack of appeal, or there was some important procedure that we normally assume is part of due process. What did Taggart say about the procedural issue?
My recollection is that Taggart involved parole hearings and that sort of thing, and I'm not exactly sure, Your Honor, the answer to that question. But what I do know is that Taggart said that without adequate safeguards, that it shouldn't be implied to mean that an entity is entitled to quasi-judicial immunity, because I think that and I don't know that there's an in-depth discussion in Taggart as to what review was available, and I think that here, if you compare it to any other type of administrative decision, the review is going to be limited to what happened below, and you've got to know what the decision was based on. You need findings of fact and conclusions of law and that sort of thing.
Let me suggest something. I'll interrupt you right there. You're cutting out just a little bit to let you know. My reading of Taggart says that the absence of procedural safeguards will not foreclose quasi-judicial immunity, implying that yes, procedural safeguards are important, but it's not going to foreclose application of this defense. And that's somewhat surprising because there's language before in Taggart that does suggest the importance of procedural safeguards, but there is that sentence in Taggart that seems to undercut your argument. Does Lutheran daycare somehow overrule that sentence?
Well, I think the court in Lutheran was careful not to say that we're overruling, but I think that they said that the safeguards are very important and that they play a big part in this. And I think that when you look at the context and the situation, that I mean, we're dealing with different animals, right? If you're considering a parole board and the types of review and the type of hearing that occurs there, and there's really not a discussion in that case as to what the lack of the safeguards were. Whereas here we know exactly what the safeguards were. We know that they had a process to make it happen. It would have been very easy to create a record, and it would have been simple to provide a decision that provided some rationale and a basis for issues to be corrected on appeal. And when you're, yes, Your Honor.
Question about how do we think of safeguards in terms of quasi-judicial immunity? Do we think of the safeguards that were actually there or the safeguards that should have been there? For example, I could think of a court hearing, right, where the judge just doesn't make a transcript and doesn't advise someone of their right to appeal and doesn't allow for cross-examination. All of those things would be reversible, but the judge would still not be sued, right?
Yeah, correct. But I think the key distinction is that you've got a record showing what the errors were in the first place.
So my question is it that there were errors, and had there been an APA appeal, we would have reversed and said, no, you got to do these things like we did in Orishi. And so therefore it's just the process itself was judicial in nature. It's just the officials violated some rules. The fact that an official violates some rules doesn't strip them of the cloak of immunity. So at what level are we thinking of safeguards? The safeguards that exist in theory and are disregarded, or the safeguards that are actually practiced?
I think it's the safeguards in the initial judicial process at that hearing, because the safeguard I'm referring to is the ability to have the record to say, here's the error. That without that, how do you correct the issue? That's my concern is that, I mean, it's one thing to say they didn't have the ability to do, conduct cross-examination or to have testimony and rebuttal and that sort of thing. But the issue is that there's nothing for an appellate court or a superior court to look at.
Well, what we would look at is what we do look at, because we've had these cases where we've said, no, we're reversing because you didn't allow the student to be present. We're reversing because you didn't allow these things. So we've just had those cases and we've reversed for a hearing under APA.
Yes, Your Honor, but this isn't a claim under the APA. It's a claim for violation of.
But it's relevant because it goes to safeguards. If you have a judicial proceeding, quasi-judicial proceeding, it's just that the hearing officers failed to follow the rules. You have the safeguard of an APA appeal, and that's the way that you get your remedy. But just because a judicial officer doesn't follow the rules that can be corrected on appeal doesn't strip that judicial officer of immunity. That's the struggle I'm having.
I understand that. And my understanding is I think I'm cutting into my time here pretty quick, but I think that WSU has argued the APA doesn't apply, that they're not required to provide a brief adjudicatory hearing. And my point is that without you might reverse it, but then what do you do a year down the road or 6 months down the road? You go back and have a hearing again on those issues, and because the reversal is typically you've got evidence that you're looking at and determining was there enough evidence, and all this deference is given to these administrative agencies. And
typically we reverse for a new hearing.
Right. Well, I'd like to reserve my time, Your Honor, unless.
Thank you so much. Yeah. Mr. Waring.
Thanks, Judge. May it please the court, counsel. My name is Carl Waring. I'm here on behalf of the state defendants. I agree with Mr. Waite's assessment in the sense of the issues that are presented. However, I'd like to approach them a little bit differently. I think for context and understanding the specific arguments, it's helpful to identify them by the causes of action that were brought below. And there's two in particular that I'd like to address in argument today. The first is the 1983 claim that was raised below the due process claim. And the second is the contract claim. And starting with the 1983 claim, the starting point for the analysis that I think is the cleanest is the qualified immunity analysis. And the reason for that is this. In qualified immunity, the burden is on the plaintiff to illustrate that two things, essentially. One, that there was a constitutional violation, but also that the law was so clearly established that every public official in that individual's shoes would have understood that what they were doing was violating constitutional law.
Mr. Waring?
Let me jump in right there because it touches upon an issue I wanted to ask you about. You argue that the Supreme Court decision in Kennard overrules the Court of Appeals decision with regard to procedural due process, correct?
I think the language from Kennard, Your Honor, actually says that they don't have to reach that issue because—
Well, it does say that we affirm the Court of Appeals in all other respects. And it's kind of tricky right there because let's say, just hypothetically, let's say that we believe that the discussion in the Court of Appeals decision in Kennard dealing with procedural due process, let's assume that we believe that it's still good law. If we assume that hypothetically, then wouldn't the rules and procedures be sufficiently clearly established to get past qualified immunity?
So taking the court's hypothetical, then the answer is a partial yes. It would be as to the procedural rules that were in place, but the threshold issue of whether or not a protected property interest existed in the first place, which has to be determined by any court that's trying to pass on the idea of, are our procedural safeguards enough to protect that interest? Because if you don't identify and define the interest, you can't then have the conversation about
page 37 of your brief, you admitted that there is a sufficient property interest.
Yeah, and I agree that that admission is there and that that language is there. I don't agree that that language binds this court. And I also think that it would then invite error by this court to try and construct whether or not procedural due process protections were adequate without actually examining whether or not there was a protected property interest.
Okay, one thing that concerns me about the process used below by the appeals committee, a number of things concern me, but one thing in particular is that we don't know what the substance of the hearing, what happened, because there was no recording. We can't look back to see what people said. For example, you've got two witnesses. I would love to know what they told the appeals process. Their names are Antonio Huffman and Dave Emmerich, because Huffman, he seemed to be very aware of the details of Mr. Webb's arrest because he spoke with the police chief. And Mr. Emmerich, he was very aware of the diluted sample just a day before the arrest. And had the committee been aware of all these things, then one might say, okay, well, the committee had enough reason to do what they did. But because we have no idea what information the committee considered, we're kind of left wondering, did Webb actually get a fair hearing?
I understand the court's concern. I think the court makes a fair point. The problem we have is there's actually a factual conflict in the record on that particular issue. If the court's had a chance to take a look at the clerk's papers at 166, you'll find a declaration from an individual by the last name of Fisher, who in their declaration actually details out that there is the ability to have these hearings transcribed. The problem that we have in the record is when we then look at the two written notices that were provided to Mr. Webb, that's not written out, it's not expressly said. And so we have this dearth about, did Mr. Webb show up at the hearing and he's advised of this, or is it available there? Did it not happen? And so to the extent there's a concern about whether or not Mr. Webb could have created some kind of formal record, we do have a factual conflict. I don't think the court has to resolve that today, because if we get to the primary question of whether or not qualified immunity would protect the individual defendants, the answer is yes. And we start with a basic proposition in a 1983 case that only individuals can be sued. It can't be brought against the university unless somebody's asking for prospective injunctive relief, and the plaintiff hasn't done that here. And so if the law wasn't so clearly established as to the constitutional claim that's in play, then all the individual defendants are entitled to have that claim dismissed against them. And the law, sorry, Your Honor.
Did Mr. Webb have a right to an APA appeal of the athletic financial aid agreement decision?
WSU does not take the view that this was a brief adjudicative proceeding.
But the statute, the APA appeal statute, isn't worded in terms of full hearings, adjudicative hearings. It just says that if there's an adjudicative hearing, you have a right to an APA appeal. So why wouldn't the APA apply to this administrative decision? If there was an adjudicative hearing.
And Your Honor, I don't believe that there's an APA appeal right to all administrative hearings, like a full judicial review that you can take up.
What's your citation for that? Because certainly the statute, when it talks about the grounds for APA appeals, you can appeal administrative decisions of the agency, you can appeal rulemaking, and then you can appeal others and other clause. And because the legislature doesn't talk in terms of types of hearings, brief adjudicative versus full adjudicative, it just talks about adjudicative hearings. What case law is there to say that we can decide we're not calling this an adjudicative hearing, therefore APA doesn't apply? That seems worrisome, because then APA could be avoided by just nomenclature.
Your Honor, to the extent that that citation isn't developed in the record, I'm happy to do any supplemental citation the court needs. But I could not tell you right offhand the particular section that I'm looking at.
Okay.
And I apologize for that.
Mr. Webb, that raises a couple of questions for me too. It has to do with the property interest. I'm getting back to the property interest, even though you've conceded it. I guess my point is that it's a fairly significant property interest. We're dealing with about 3.5 years left of a scholarship. That potentially is $100,000 of a property interest. It was taken away from Mr. Webb by a process that, depending upon which side of the issue you're on, you may consider very dubious. The process itself, where he wasn't even there listening to the evidence against him. It's a significant property interest. And in addition, when a person loses a scholarship, they very well may lose the opportunity for a college education. Not everyone can afford a college education. Is there anything in the record that shows whether Mr. Webb continued going to WSU after he lost his athletic scholarship?
I believe the information in the record is that he did not continue his education at WSU, but that WSU did reach out to Mr. Webb to help facilitate that. I can't tell you from my own recollection of the record whether or not he took advantage of that opportunity or not. But to address the court's concern about whether or not there's a property interest there, I would concede that there certainly is an expectancy there, but an expectancy isn't the same thing as a constitutionally protected property.
Well, he said he would get the scholarship, he would keep it unless if he violated certain rules. That seems to be more than an expectancy. It wasn't like in the previous case of Pinard, where the Supreme Court said, hey, look at this language. The Student Financial Services would only have to, consider the person, from year to year, whether they should keep the scholarship or something of that nature. It was much more looser language, but the language we're dealing with here in the financial aid contract, it made it very clear that this is a 4-year scholarship plus some change, unless he violates these rules.
And I think where we differ in our reading of whether or not there's a constitutionally protected property interest versus an expectancy can be teased out at page 321 of the record, where we actually see the athletic financial aid agreement and where it goes through what the agreement is precisely. And the reason we label it as an expectancy rather than a constitutionally protected property interest are the conditions that are listed there, which include, and it's difficult to cite the paragraph, but there's a paragraph E under one of the conditions that talks about athletes losing their scholarships for any violations of non-athletically related conditions outlined in the financial aid agreement or violating a document.
Let me ask you a question about that. I've got a property interest in my house, right? But it's conditioned upon me paying the mortgage. I mean, there's lots of things that go beyond expectancy for a property interest that can be lost.
And I think that your property interest in your house is to the extent that you have the equity. What you've paid is certainly yours, but the rest of the home and the value in it, if you don't pay for it, you might have an expectancy, but you don't have a entitlement to that value.
But if the state's going to take my home away from me, it better give me due process.
And I don't disagree with that idea. And how we figure out what the measure of the required due process relates to the property interest that's at play. So one of the things
the U.S. Supreme Court has said that there's a property interest in welfare, essentially, that before a welfare recipient can be discontinued, that there's a right to some sort of due process hearing. In a lot of ways, this is similar. This is how Mr. Webb was planning on living for the next few years. Why, if there's a property interest in continued welfare benefits, is there not a property interest in continued receipt of a scholarship that pays room and board and tuition?
Because it's not the same nature of the welfare benefits.
Why is it substantively different?
Because what we're talking about in Mr. Webb's case in particular is an athletic financial aid agreement. So in other words, because he was talented enough to play football at the collegiate level, he was getting the benefit of athletic financial aid. Not everyone is going to get that benefit, and it's certainly not a right or a privilege. There's a host of federal cases that talk about athletes not having any independent constitutional right to play collegiate sports. Now, when the athletic financial aid agreement is taken away because Mr. Webb violates team rules, he isn't in any different position than any other person who wants to go to college. He's still eligible for other forms of financial aid or to pay for it independently or to go to other schools. And the difference between that and a welfare recipient is that very well could be the end road for them. If you don't get your $500, you're not putting food on your table. That's not the situation that Mr. Webb was in at WSU at all. And
I disagree. I think Mr. Webb had a full paid scholarship for 4 years, athletic scholarship. And once that was taken away, yes, he could have received aid, but the aid he would have received was not a full scholarship to go tuition free. It was something he'd have to pay back.
Agreed. And by not playing on the football team, let me rephrase that. When he's accepting the athletic financial aid agreement, he is paying something to the university. It's not money, but it's his time and his talent in representing the university. And when he broke that agreement and he's no longer willing to pay that any longer to the university in exchange for the free scholarship, there isn't anything improper about him returning to the same status as anyone else who wants to go to school, who has to pay back their financial aid. He was doing that all along.
Contract issues. You've got a little over a minute left. Go ahead and tell us what you want to discuss about the breach of contract claim.
I guess just real briefly on the breach of contract claim, we have to start with which agreement the plaintiff is saying creates the contract so that we can understand what terms they say are breached. The only express contract that was present in this case was the athletic financial aid agreement. That agreement did not incorporate the terms of the student handbook, either expressly or impliedly, into the contract. And as the court's aware from our citation to the Rootsager case, that issue's been analyzed at least by a different court. It's certainly not binding on this court, but it's persuasive precedent or precedent this court can look to, just for the understanding that the athletic financial aid agreement doesn't make this whole student handbook a contract. And then finally, if we then turn our attention to the student handbook, there is no express provision making mutual obligations on both parties, consideration, or the other elements of a contract. And so for those reasons, we would ask the court to find that there was no contract.
I do have one question. This probably is a better question for Mr. Wade, but I'll ask you too. In reading the appellant's opening brief, I saw them make the first argument that the handbook was incorporated by reference. I didn't see the second argument where they were saying it's directly a part of the contract. I see that in the reply brief. Maybe I need to read it again, but were both arguments made in the opening brief, appellant's opening brief?
I didn't catch it in the opening brief, Your Honor.
I didn't either.
It was there.
Okay.
And I understand my time is now well over. Thanks for your time, judges.
Despite your time being over, I have a few questions for you, Mr. Waring.
Yes, sir.
I'm confused. Is the state conceding that there was a property interest in the financial aid by being an athlete, or not conceding?
I have to admit that in our opening brief, that was a concession that was made. And then I have to caveat that with, I think that invites error by this court, and I don't think the court is bound by that concession. The reason it's significant is for qualified immunity analysis.
Is the state denying today that there's a property interest?
Yes, sir. We're saying it's an expectancy.
And you distinguish between a property interest and an expectancy. In my mind, some reasonable expectancies become a property interest. Are you saying that's not true?
It can be true when it crosses over into an entitlement, but until it becomes entitlement, no. And the reason that we draw this distinction is if we look at the Conrad decision from the state Supreme Court, albeit there's factual differences between the two types of financial aid that were in play. But if we examine the facts of Conrad, there was evidence in the record at that point from the WSU football coach, from the UW football coach, Don James, at that point, that in the players expected that as long as everything was going okay and they didn't violate team rules, those were going to be renewed. And then another individual from University of Washington also indicated that that was the practice. You would renew these one-year scholarships as long as there weren't problems, as long as the recommendation came from the coach. So our position is there's really no meaningful difference when we get to the meat of these two different agreements. They both were just expectancies, not entitlements.
Mr. Waring, I think
finally, are the committee members arguing absolute immunity or qualified immunity under Section 1983 or both?
So for the quasi-judicial immunity, they'd be arguing absolute immunity. For, I'm not sure if I just said that right, Your Honor. Let me go back. For the quasi-judicial immunity, it would be absolute. For the qualified immunity, it's the normal analysis under 1983. In other words, the law would have to be so clearly established at the time they took their actions that they would have, not just they, but every reasonable official would have known that the action they were taking violated due process rights. And because of the confusion in Conrad, the Austin case out of Oregon that in 2016 says it's not clearly established as if this is a property right. There's no basis to impose liability under 1983 on these decision makers.
Thank you for the extra time, Chief Judge.
Thank you, Mr. Waring. Mr. Wade, I'll give you some extra time as well. So please proceed with your rebuttal. And you are on mute.
I apologize, Your Honor.
Thank you.
Mr. Waite, is Zaire Webb seeking to overturn the Athletic Award Appeals Committee's ruling as part of this case?
No, I think we're seeking to overturn the decisions by the trial court, Your Honor.
Does Zaire Webb challenge the neutrality of the members of the Athletic Award Appeals Committee?
Well, we haven't specifically in the briefing, but I think that there's questions as to the adversarial nature of that process in light of the fact that these folks work for the university. They're called directly by them to appear on the board. And so I think that's part of the problem is we can't really determine the neutrality of and the objectiveness of the committee members because we don't have a record.
What actions or omissions of the committee members or WSU constituted negligence?
The failure to provide a reasonable hearing.
Is there any case law that says there's an actionable duty in tort to provide a reasonable hearing or a hearing with proper process?
Beyond the cases that reference constitutional torts that are provided in my brief, nothing that I could find. But specifically addressing whether or not due process issues create a duty and tort. Not that I found. If I may, I'd like to point out a few things. That the fact that entitlements can be revoked or changed or taken away doesn't render them expectancies. I don't think that's a reasonable interpretation of all of the existing law that defines property interests and how entitlements are created. And another point that was made by Mr. Waring was that we've got a factual question as to whether or not Mr. Webb was provided the opportunity to make a record. And looking at page 166 that he cited, the only thing that Ms. Fisher says is that the student athlete can address the university's basis for revoking financial aid with or without the representation of attorney, and can have the hearing transcribed if he or she wishes. There's no testimony that he was provided any kind of notice that he could have the.
Isn't it up to the university to provide due process and not Mr. Webb?
I'm sorry, Your Honor, I didn't catch that.
Isn't it up to the university to provide due process and not Mr. Webb?
Yes, did I misspeak?
No, you just, I just don't think it's important that Mr. Webb was advised he had the right to have something transcribed because it wasn't his obligation to provide himself due process. Let me ask you a question here that we haven't gotten into. The record shows that there is a separate committee, I think it's called a Student Disciplinary Committee, that they found that Mr. Webb had not actually shoplifted the merchandise from, I believe it was it Wal-Mart?
Yes, Your Honor.
Yeah, but what evidence did they consider? I know that there's a footnote in the university's brief that says that they didn't even, listen to the security guard or take evidence from the security guard or the police officer. What evidence did the Student Disciplinary Committee consider, if we know?
Your Honor, I'm not sure. I do know that the criminal charges were dismissed. And I would say that whatever happened in the conduct hearing is, I wouldn't think that it has too much of a bearing on whether or not due process was provided in the financial aid context.
No.
But to answer your question, I'm not sure what all they considered. I know that Mr. Webb disputed it and ultimately was found to have not violated the.
Did the athletic department participate in the Student Disciplinary Committee hearing?
I do not think so, but I do not know.
They didn't receive due process.
in the other context, but we're dealing with due process for the revocation of a hearing, and I think the point is that you have to know what you're being. I'm not sure that I'm tracking, but the other thing that I wanted to point out on the contract side, if I may, is the reliance on Ruegsager actually benefits Mr. Webb in several key aspects. The most important distinction is that when people provide handbooks and policies that are going to be followed, they have the ability to put the folks that are provided the handbooks on notice that these shouldn't be construed as a contract. There are conspicuous disclaimers that can be included, as recognized by the Washington Supreme Court in Thompson, when they said, if you tell somebody that a handbook isn't a promise, then it's not a promise. But if you don't tell them that and you say, we're going to provide systematic and fair treatment, and this is how we're going to deal with you if this specific situation occurs.
Then Mr. Wade, let me interrupt you right there because I see you're running short of time. And I want to make sure I get my questions to you about what you're talking about. First, Thompson and the progeny of Thompson, that's all employment. Have you ever seen it extended to non-employment context?
No, Your Honor, but that is the most analogous situation. And in Ruegsager, which WSU relies on, the court specifically recognized that the employment context is the most analogous situation, and the contract law is what it is. I think that the law is still based in contract, and whether or not a promise and an obligation are created is.
My second argument is this. Did you make that precise argument on the contract theory Did you make that at the trial court and in your opening brief? I didn't see it in your opening brief.
I know that I argued that the contract was incorporated and that
Yes.
that a specific yes, Thompson and all that whole line is cited in the opening brief.
But your argument, though, was in the context that the handbook was incorporated by reference. You didn't raise it as a separate argument, did you? The whole Thompson theory?
Well, yes. I mean, it's there. I think you can go about it either way, whether it's incorporated by reference, which I think that it is. If you look at the plain language of the agreement that references the policies.
Yeah, I know that we don't typically, allow an issue to be raised for the first time in a reply brief. And that argument, I think, was better made in your reply than in your opening. I need to take another look to see whether or not you actually made it in your opening too.
It is, Your Honor. The Thompson case and that line of logic is all there. And regardless, it's a contract expectation that the university created.
Okay.
The other thing, getting to the qualified immunity piece of it, if there is not clearly established law in this instance, I don't know when there will be. We've got a case that's on all fours square with what happened here. We've got a scholarship that was terminated, and then the exact process that needs to be laid out. And the requirement isn't that every official needs to know about it, and to hold that that's the case, it almost encourages public entities to tell their employees to put their heads in the sand. Let's not find out what the law is for fear of violating it and then not having immunity. That is awful and destructive precedent. And really, if any of these issues are a close call, I think that the appropriate thing to do here is to make sure that in the future that universities have a set of rules that they follow and that their feet are going to be held to the fire. And then it's important not just to deprive people of their constitutional rights without providing these very base level protections, because in this instance, it's pretty clear that the deck was stacked against Mr. Webb. There's no explanation as to what the extra administrative burden would have been. There's no discussion of why he needed to be excused from the room. And WSU is contending that the APA is inapplicable and he didn't have any appeal rights on top of it. So that gets back to the quasi judicial immunity point where there are no safeguards. WSU is saying, no, you couldn't appeal this. The decision is final. We're not making a record. This is what you're stuck with.
Thank you. I think that I've given you the same amount of time that I gave Mr. Waring, so we will go ahead and submit this matter.
Following these arguments, the court reversed the trial court's decision, finding Webb had a claim to this scholarship and his right to due process was violated. The committee deprived Webb of a meaningful opportunity to be heard and to call his own witnesses. Additionally, the 2018 lawsuit against Washington State University was settled for $275,000.